Hi, my name is Chris Nolan. I'm a barrister at Queen Victoria Chambers in Sydney. This video is called How to Plead Guilty, and it's designed to assist legal practitioners appearing in the local court of New South Wales. I was called to the bar in 2006, and in that time I've heard many lawyers make submissions on sentence, and almost all of them could have been greatly improved if those practitioners understood the sentencing exercise and their role in it. Your job as a lawyer is to assist the court and assist the magistrate in the sentencing exercise, and so the magistrate is expecting 5 things from you in a particular order. The first thing the magistrate expects is a properly amended statement of the facts. So when that fact sheet is handed up, if it contains irrelevant material or material that is prejudicial to your client, you will be falling in the regard of the magistrate. They will think either you don't know what you're doing or you just don't care. Either way, it's not a good look. Well, on the other hand, if the statement of facts has been amended and there is no objectionable material in it, you will rise in the esteem of that magistrate. And this is all even before you've begun making your submissions. The second thing the magistrate will expect from you is your client's explanation of how the offending occurred. And so if they're charged with assault, the magistrate will want to know how they were provoked into a fight. If they were drink driving, then the magistrate will want to know where they were driving to and why it was so important that they put themselves and other people at risk. If they are charged with a drug matter, the magistrate will want to know how they became involved in drugs and what they are doing to get off drugs. The third thing the magistrate will expect from you is a list of mitigating factors that apply to your case. Now, the list of mitigating factors is found in the statute of section 21 capital A of the Crimes Sentencing Procedure Act. You can just go down that list and tick all of the factors that apply to your case. The fourth thing the magistrate is expecting from you is the most important. Those are the subjective features of your client. Now, there's a paper on my website that explains the importance of subjective features, and there's another video to accompany that paper. Subjective features is basically the history of your client. The magistrate doesn't want to hear his life story. Your job is to hear his life story and then pick out the parts that are relevant and will assist the magistrate in their sentencing exercise. So they will expect evidence to support all of these submissions, including a letter of apology from your client and character references from his employer and from a family member to support these assertions that you are making. If you are claiming any kind of mental or medical impairment, the magistrate will expect a medical report to support that. And if your client has completed any courses, like the Traffic Offenders Program, they'll expect a certificate from the course provider to confirm that. The last thing that the magistrate will expect from you is to be addressed on the purposes of sentencing. The purposes of sentencing are found in section 3 capital A of the Crime Sentencing Procedure Act. There are 7 of them. So indeed, punishment is one of the purposes of sentencing, but there are 6 others. And the magistrate will expect you to address them on each of them because they are required under the law to consider those purposes when they pass sentence. From a defence lawyer's point of view, the most important purpose of sentencing is probably rehabilitation of the offender. So if your client has committed an offence involving drugs or alcohol, then or if they have a mental health problem, then you should be saying an awful lot about how they're being rehabilitated, and you should have some medical evidence to support that assertion. So your submissions will then finish with a recommendation on sentence, which should be reasonable. And if I may say, my final word is I highly recommend that you put your submissions in writing. There is nothing you can say out loud that you can't write down, and everybody is impressed by written submissions. Furthermore, if you do them right, you really only have to do them once, because once you have that template written, you just have to make amendments to that for each new case that comes to you. So written submissions impress the client because they get to see what they're paying for and they get to approve it ahead of time. Also, it means that you don't have to tell a room full of strangers about the offence that they have committed, which might be extremely embarrassing for them. Prosecutors are very impressed by written submissions. If you give them to the prosecutor ahead of time, the prosecutor can take a look and raise any issues with you before you appear in court, which means you can then think about, do I want to press this issue, in which case you'll need some evidence to support your position, or you might decide it's not worth pressing that issue and just remove it from your submissions. And then the magistrate will be extremely impressed because it saves the magistrate time, it proves that you have done the work, they can read them much faster than you can read them aloud, and if they're agreeing with what you're saying, they can just skip ahead to the parts of the submission that they feel are important. So if it's done right, you'll walk into court and you'll announce your appearance, you'll enter a plea of guilty and hand up the facts, the record, and your written submissions, at which point the magistrate will read them to themselves, and then ideally they will say, thank you, Mr. Nolan, your submissions are extremely helpful. They'll ask the prosecutor, do you wish to be heard? And ideally the prosecutor will say, no, I don't wish to be heard, which is his way of saying, I agree with everything Mr. Nolan has said, and the magistrate can feel very confident that you have done your job correctly, that the police are not disputing anything you have said, and most likely he or she will give you the sentence that you have recommended for the reasons in your submission. Thank you for your attention.